Hello, my name is Jubin with Dana Legal Services, and in today's video, we're going to talk a little bit about what happens when your patent application gets examined and your claims are rejected. Is that common? Is that something that should happen? How does that system and process work? So as you know, when you work with a patent attorney or if you do it on your own, you file your patent application, and after a certain period of time, an examiner from the US Patent and Trademark Office will pick up your application and examine it. What does that mean? That means they will look at your claims and what you have described in your invention and your figures, and based on that, do a search to see if there's anything out there in terms of a reference that discloses what you have claimed as your invention. If so, they reject your claims. Now, most often you can see that the rejection they're giving you is based on your claims being interpreted in the most broadest possible way, in which case you then would talk to the examiner. I would set up an examiner interview if you were working with us, and we would chat with the examiner to learn a little bit about how the examiner is interpreting the claim language, and then decide what we need to do with your claim. Keep in mind that when we make changes to your claim, it changes the scope of your invention. So we have to be very careful about making your scope too narrow to the point where your patent means nothing. But anyway, so your patent gets examined. The examiner rejects it. Is that the end of it? Absolutely not. We go to the examiner. We can have a discussion with the examiner. We can not have a discussion with the examiner, which I would not recommend. I mean, if you have a chance to have a telephone interview with the examiner, why not take it? Why not have that discussion where you can clarify things, have a lot of dialogue, and avoid creating a bunch of written file history, which then can be later used against you. So once you have that discussion with the examiner, you can go away, make some amendments. You can even ask for the examiner to look at a proposed amendment and give you an idea as to whether or not this will help your case. Then you file the response to the rejection. So you got a rejection. Now you talk to the examiner and made some decisions about what you're going to do, and then you file that response. When you file the response, the examiner will pick it up, look at your response, and then give you another office action. Either they'll tell you, yes, this helped your case and your claims are now allowable, or this helped your case, but it's not good enough because I found other references, or this did not help your case at all. So hopefully you're in a situation where you know it's helped your case because you interviewed the examiner. So your claim got rejected, you interviewed the examiner, you filed a response, the examiner issued another office action. How many office actions can you have? Is there a limit? The answer is no. You can have as many office actions as you want as long as you're willing to pay. If you pay, which is called a request for continued examination, then the examiner will do another round of analysis with you. Sometimes you get to 2 or 3 rounds of request for continuous examination. Sometimes you do the first action, you talk to the examiner, you did a good job of understanding the situation and explaining your invention to the examiner, and then the next response you file ends up in getting your patent allowed or granted. So, in summary, is it common to get a rejection from the patent office after you filed your patent application and they've examined it? The answer is yes. In fact, I would say that if you don't get a rejection, you probably didn't ask for enough. You made your claims too narrow. If you get a first action allowance, you probably want to go back and see if you can broaden the scope of your claims. So my advice, make sure that when you file your claims that you're not making your claims too narrow. It's a good thing to get a first office action that's a rejection because it means you asked for too much. My name is Jubin Dana. I'm with Dana Legal Services. Here's our contact info. If you want, reach out. We're happy to consult with you. If you filed your own application and you need input because now you have an office action and you have no help, we're here to help you. We'll give you some advice and some guidance. Take care.